Let's kindly to mention, my lord, suit of 1987, my lord, my application for being examined, my lord, pro intestis suo, my lord. I have filed, my lord, the application accompanying, my lord, master summons, my lord. My lord, the department is telling me, my lord, I have to enclose it with a notice of motion, my lord. I'm only praying leave, my lord, to file this application with, my lord, the master summons, my lord, as did permitted, my lord, by the original side. Great. Great.
Already mentioning?
রশিদ দয়া করে যদি অনুমতি করেন ইনফাস্টিং একটু প্রার্থনা জানাবো। রশিদ আমার দাদু একটাই উইল করেছে, সেটা টেস্টামেন্টারি শুট নাম্বার GS12012। আর আমার বইমাত্র দাদা আমার পুণ্যশ্রী সিনেমার মালিকানা আত্মসাতের জন্য
কাগজটা জমা দিন, পরে দেখা হবে। যা কাগজ আছে জমা দিন, পরে জেনে যাবেন কি অবস্থায় আছে।
দেওয়ার জন্য প্রার্থনা জানাচ্ছি।
ঠিক আছে, কাগজটা জমা দেখে নেওয়া হবে, পরে জেনে যাবেন ওটা কবে দেওয়া হবে।
কবে রশিদ বারবার আশাটা
আপনি জেনে যাবেন, পরে এসে জেনে যাবেন।
আপনাকে বলে দেওয়া হবে পরে, আপনি পরে একবার আসবেন, পরে
আমি এখন অপেক্ষা করছি, একবার জেনে চলে যাব। কিংবা রশিদ যদি দয়া করে আদেশ করেন আদার সাইডকে নোটিশ দিতে, যেটা বলবেন সেটাই হবে।
ঠিক আছে, আপনি যদি জানিয়ে আসুন, আদার সাইডকে জানিয়ে আসুন, এটাকে নেক্সট উইকে রেখে দেওয়া হবে, সামনের সপ্তাহে।
তাহলে বৃহস্পতিবারে মেনশনের জন্য ওনাদের চিঠি
সামনের সোমবারে এটা থাকবে আর কি।
সামনে সোমবার, তাহলে পেপারটা রইল, আমি ওনাদের চিঠি জানিয়ে দিচ্ছি।
একটা নাম্বারের স্লিপ দিই না,
ওতেই রয়েছে, অর্ডারেই রয়েছে।
দেখে নিন, দেখে পরে দরকার হলে যাবে।
3টে শুট আর 5টা জি অ্যাপ্লিকেশন।
চেম্বার অ্যাপ্লিকেশন adjourned.
My lord, I am seeking a short pass over. Mr. Thakkar is on legs.
Yes, pass over.
Item number 2, the chamber application Joydev Mondik.
I am praying for not today, my lord, due to my senior's eye problem.
For petitioner?
Petitioner.
Okay, not today.
I am seeking for the adjournment. 3 and 4. I am seeking for the adjournment.
You're for the petitioner, both the matter?
Petitioner, both the matter.
Okay, not today.
Kindly fix, my lord, one week.
Not today means it will be taken up on Tuesday, next chamber day.
Okay. Next Thursday. Yeah.
Item number 5.
But there are various applications here.
14 that was disposed of by your learned by Justice Lord in this matter.
Item 5.
Yes, item
No, Lord, I'll tell my lord.
Certain GS were dismissed on the last occasion. We have preferred an appeal from the dismissal of GF 14, your lordship. That is pending.
GF 14 is not appearing. Yes, my lord, because it is disposed of. And appeal has been preferred. That's pending.
In the list.
Now, my lord, today, my lord, whatever applications are appearing, my lord, I'll seek certain further orders. Some applications were.
Lordship would kindly keep this pending.
Well, Lord, he is not concerned with the other portions of the premises. GA1 for?
Yes.
Well, Lord, GA1 is for police help. This is my application. Okay, now GA2? GA2 is an objection to the report of the receiver. So these GAs are to be disposed of?
Yes.
Yes,
Is
my lord.
there any stay of further proceedings?
No, not at all. There is no stay. On the last occasion, certain GAs were taken up. They were disposed of.
Which is listed before your lordship, that is similar to GA14 that was disposed of. GA15 is my GA15. My
Yes,
application.
but the GA14
kindly
is
keep this
firstly
pending.
GA14 is not there in the list. It has been
GA15 is similar to
disposed of.
GA14.
Disposed of.
15 which is appearing in your lordship's list, that is similar to
GA15 is to be heard out. GA15 is to be heard.
Yes.
And my lord, there are other portions of the premises apart from other GAs. There are other portions of the premises which have remained unchallenged. My lord, the occupiers have not challenged the decree and neither have registered possession. Now, my lord, what GA1 says, GA1 is the basis of GA1 is, my lord, there is certain obstruction in the premises with regard to certain portions. Now, my lord, we need police help to take possession of those premises. There is no stay of the decree, and I'll indicate to your lordship.
So
It's
GA15 does not.
GA15 is
But
my
GA15 is one of the registers.
GA14 from which an appeal has been preferred.
My lord, let us, my lord,
The
GA
question
15,
in
since it is
GA 15
contested, since it is contested, GA 15, my lord, I'll trouble your lordship with the other
What
portions.
relief did you seek for in GA 15? GA 15 is similar to GA 14, which has been disposed of and from which an appeal has been preferred. That is
Yes.
pending before
My lord, I'll indicate, my
courtroom
lord.
37 today.
I'll indicate, my lord, insofar as the objections are concerned, whatever GAs are there on the list today by the registers, I'll not trouble your lordship at this moment. Insofar as the portions which have not been challenged by the occupiers there, I'll seek orders for police help
That
to
can
take
wait.
possession. And that is why I'm
Because
saying my learned
my
friend need not be
premises is
troubled.
That is GA1, GA,
GA1, if your lordship is kind enough to take up.
তো আমার না ভাই
Other portions concerned.
Other than as forming a subject matter
Of the
of the GA 15. That's it.
If your lordship takes up GA1,
yes, GA1.
GA1 kindly take my master summons. Here, my lord, I am seeking, my lord, help of the Commissioner of Police through the jurisdictional police station to render assistance to take khas possession of the portions of the premises. It's a 2015 decree upheld by the Supreme Court.
Appeal. Appeal. What is this allegation of obstruction? Which prayer? Which
But
paragraph?
GA1, yes, ma'am.
Yes, GA1, which paragraph you have stated?
But GA1, if your lordship kindly takes. But paragraph 23, page 10, paragraph 23.
Yes.
But from 23 onwards, there are certain occupiers of portions of the premises who have not come before this court, neither have challenged the decree. But 23, 24, and 25, it is the basis of my this application.
No, there was an obstruction while the receiver
Yes.
attempted to make an inventory.
Yes, yes.
So that inventory could not be made.
But thereafter, subsequently, it has been done.
Subsequently, it has been done.
And the report of the receiver is also there on record.
Yes. Good report is attached.
But,
This is the report was submitted by the receiver
Yes,
that
yes.
there was some obstruction.
yes, but after firstly he
Usually
faced
what happens is this, what is the provision is this, when the sheriff or the bailiff faces obstruction while attempting to deliver possession, okay, he submits a report and the police help applications are made.
Malad, here, Malad, if your lordship is kind enough to direct the sheriff to go to the premises and take possession.
Yes, thereafter on the
Very well,
if
Malad.
there is any
Yes, Malad,
obstruction,
I appreciate.
this is the
Malad,
procedure which is followed.
Yes, Malad,
And
absolutely.
usually police help orders are passed upon hearing the obstructors.
Upon hearing the obstructor,
Yes,
but
this is
nothing,
the normal
nobody has come
procedure.
forward. So if your lordship sees prayer A of my master summons,
Yes, that can be considered.
kindly grants that. They are not concerned. They are not
It is not
concerned.
my lord.
My premises is not being
Well,
covered.
that I'm making that prayer. Sheriff will go there insofar as
Which is the decretal property?
well, 33 by 1.
Yes, in your petition.
Yes, Manat, I'll indicate. Rest of the welcome, Pratham. But I mean, led by Mr. Mitra, Lordship, kindly grant relief.
No, this is my execution
So
application.
what happens is this, what I have just made it, that when an attempt is made by the bailiff, that is the sheriff, and there is an obstruction, the sheriff comes and submits a report, and police help application is made, and usually police help orders are passed upon hearing the obstructors. Okay, that is done.
We wanted the first step to be done.
Yes,
Okay,
that is
sheriff
sheriff
to-
should go and hand over the position.
The property is in the details are paragraph 2, page 3. Next page 3,
Page 3,
paragraph 2. Next no,
page 3, that is,
paragraph 2.
okay. Yes, suit premises, that is suit premises is 3 by 1. Aneta is 33 by 1.
By the other side. Find that. Yes.
So entire 33 by 1 is the suit premises. You have sought for vacant position of 33 by 1.
Slightly more background, if I may give, my lord. There are Order 21, Rule 97 applications by the sublessees. I have got decree against the defendant number 1, who's my lessee, and its sublessee, defendant number 2. It's from 88 suit, it went up to Supreme Court in 2019-21. Now, Order 21, Rule 97 filed by sublessees who have derived their title from the defendant number 2 sublessee. Several applications before Justice said, several of the applications were taken up and were heard and dismissed with costs. No stay as yet granted. So, my lord, I would humbly beseech, my lord, that judgment factually will be relevant because that's between the same judgment debtor and the same decree holder. Sublessees are different. Now, some applicants who have come forward here, they don't even have the right to file out of the Rule 97 because they are pending liability transferees. Post-suit sublessees.
As of today, there is no stay of the execution.
No
proceeding.
stay. They had enjoyed the up to Supreme Court, dismissed twice. Where is that? Where is the judgment?
I had 2 applications, but they were not dismissed. They were adjourned. GA number 10 and GA number 11. But to move those applications, I was asked to deposit cost much in excess of permissible under CPC. I have preferred appeals; those are pending. Those have not been taken up yet. I mentioned. And I have 4 room numbers. 2 applications, 4 room numbers: 803, 804, 805, 806. And I may get some time, to prefer my appeal. Otherwise, but only those, I'm giving the details to the court.
For those
Applications will be taken up.
I am not asking for execution against him. I am only applying for today police help.
That is judgment date has.
Judgment date 1 and 2. Those whose Order 21, Rule 97 has been dismissed.
Yes, yes.
Only against those.
Mahabir Properties Private Limited
They are the judgment. They have not filed Order 21, Rule 97.
and Marshall Sons.
But those whose Order 21, Rule 97 are still pending, I am not asking today. I shall be, though I would be entitled to because they have not paid the cost.
So for these 2 judgment dates are concerned, there is no application pending before any forum. So for this present 2 judgment dates are concerned.
Yes, they are not present. But Order 21 is filed by third parties. Now, those who are claiming sublessees, there were several filed. My learned friend's application was adjourned, subject to payment of rupees 3 lakhs in costs. Now, if they did not pay, it would stand dismissed. So just a minute. So they have not paid the cost. It has stood dismissed by implication, by law, because as per the order, they have not got any stay. almost a month over. They can keep their appeal pending as long.
That they have a separate right.
And they're right. But as of now, their application dismissed. Mother, five other applications ordered under Rule 97 have been dismissed on merits. Some cases appeal preferred, some cases appeal not preferred. Where appeal has been preferred also, there is no stay. Now, mother, there are certain other portions of the building where there is no Order 21 at all filed. So those portions I am anyways entitled to get possession. So today there is no stay at all of the decree. So I'm humbly praying, let the sheriff go.
That is paragraph 19.
Paragraph 90.
Paragraph 23.
23 talks about the obstruction
Okay.
and so let the sheriff department somebody go if the next stage shall take.
Senior said he is not proceeding against me.
No. Not against you, of course,
Today.
because
May I
because
only, my lord,
no,
give my
I'm not police
application
help. I'm not seeking police help. I'm not seeking against you.
Today, whatever order is being sought for is against those judgmentators against who have not filed any Order 21 Rule 97.
And those who have been dismissed, those who have been
And those
dismissed,
whose applications are
have been
no more
dismissed.
pending now.
No more pending. Those not filed and those who.
Anyway, this is not before.
My one, my lord, was adjourned. For the cost, my lord, I have appealed. May I only give my GA number and my
Well, there are only two GAs pending: Order 21, GA 12, and GA 15, both of 2024. Leave aside those parts. Rest. There is no. There is either not pending, or pending, or filed and dismissed, or filed and dismissed. Filed and dismissed is not pending. Filed and dismissed is either filed and dismissed.
It is continuation of the same process.
No,
Appeal is pending.
appeal pending means doesn't decree or doesn't get stay. No, there's no stay.
Only for that, my lord, I'm not getting a chance to move my appeal today because of, my lord, the court's business. It's not permitted.
Yeah.
I had mentioned, my lord. I was
Anyway,
told
that's
it was not listed.
that may not the court's business may not permit for the next 5 years, but that does not mean. But the law is that if there is no stay, it has to proceed.
Yes, take down. Mr. Mitro, learned advocate for the degree holder petitioner is present. An application PA1 of 2021 filed praying for a direction upon Sheriff of Calcutta to visit the said suit premises and hand over harsh, vacant and peaceful possession to the degree holders. It is Mr. Mitro submits that his client is pressing for handing over possession of those areas where no application under Order 21 Rule 97 of the Code of Civil Procedure is pending and where this order has reached its finality. You are appearing for?
Applicant in GA 10 and GA 11.
No, so far this matter is concerned.
Yes, I have applications which are pending in this execution.
If it is pending, if you honestly show the pending, then that will not be.
The appeal is continuing.
No.
The judgment debtors did not appear.
I'm appearing on behalf of judgment debtor number 2, Your Lordship.
They have lost up to Supreme Court.
I have lost everything, Your Lordship.
Although learned advocate for the judgment debtor is present, but he submits that the decree has reached its finality till the apex court. Upon hearing the learned advocate for the petitioner and considering the facts of the case, this court is of the view that necessary direction upon the sheriff should be passed. Hence, the sheriff is directed to visit the premises
33 by 1.
33
33 by 1, Netaji Subhash.
premises number 33 by 1 Netaji Subhash Road, Calcutta 7,01,000 and hand over vacant and peaceful possession of the said premises to the decree holder and or their authorized representative. Thus, let there be an order in terms of prayer A of the master summons dated 8th day of March 2021. The sheriff shall hand over the vacant position within a period of 2 weeks and submit report by 15/5/2025. Learned advocate who is appearing for the applicant and who have applicant in GA
10 of 2022 and 11 of 2020.
GA of 20
10 of 2022
10 of 2022 and
11 of 2022.
11 of 2022
I am
submits that his applications needs to be heard as he is also affected.
It even dismissed.
no.
How can it be heard?
There was an order for cost against
Okay.
which I have gone up in appeal.
No, as
The appeal is
because an
pending.
appeal is pending, he may pursue his appeal within the said period of 2 weeks.
But till then, my lord, my rooms, I have 4 room numbers which I am, my lord,
You
occupying.
you see, I have
Understand.
granted 2 weeks time to the sheriff.
Yes.
Within these 2 weeks, whatever you want to take steps, you take steps.
My lord, in that 2 weeks, my lord, let him not, my lord, only my room number. There are, my lord, 100 other rooms. There are 800
There are 800
occupiers. Instead, he is moving
occupiers.
against people
2 weeks
who have
time
not
I have
done
given.
anything.
Okay, let it be brief to comply within 3 weeks. Okay. 3 weeks and submit a report by 22/5/2025.
Today, my lord, they are moving against people who have not done anything. My lord, who have not come
No,
to
I'm
court
moving
and-
the
Have
over
obtained
entire
if he
property.
has obtained a degree of the
Yes.
suit property,
Yes.
he is entitled to get possession
My
of the
lord, he
degree.
has-
You
his
get a stay
qualities-
for-
my
you
lord,
get a-
you've seen
Whatever it
today
is, you see,
defendant-
at this stage, this court cannot go into
You
this.
get your
Only,
stay.
my lord, my rooms not be, my lord,
You
for
see,
3
I have
weeks.
granted this 4 weeks time.
Give me 2 weeks at least then.
No,
my lord, For
no.
my rooms to not be affected.
You obtain an order from the appeal court that is pending. That is why I have granted 3 weeks time.
I have filed an application back to this back to the that application was hard. That application I received application order to that I have alleged fraud in the decree.
Question is what is that disposed?
That has been dismissed.
Yes, if it is dismissed, you see,
There is a way.
very well.
There this before the
You see, next you have a entire opportunity to take steps in the next week. I have granted the belief opportunity. I have made it clear that 3 weeks it is to be handed over and report to be submitted within 1 week. Whatever you want to do it within these 3 weeks.
But tomorrow itself the belief might go, then I will not get any protection.
Yes.
Instead of the direction for handing over, let the sheriff go there and file a report. Make an inventory, file a report. In the meantime, at least we get a chance to the appeal court. My appeal will keep. For inventory at the execution stage, inventory. This is in the CPC. For disposition. Tomorrow,
My lord, tomorrow if the sheriff goes, I will lose my chance.
Okay.
It's appearing in the list.
my appeal is being.
So right. So
Only-
tomorrow you take steps.
Today I will take steps.
Today, I will take, my lord, only give.
Lordship can say, bailiff will go, sheriff will go after 1 week. Can you provide that?
Okay, it is hereby made clear that the sheriff shall visit the suit property for the, no, one hand I am making it 3 weeks.
Yes, then there is no point. Very well, Lordship.
Okay, just 1 minute. Okay, it is hereby made clear that the sheriff may visit the suit property after after 7/5/2025 to enable the aggrieved parties to take necessary to enable the aggrieved parties to move before the higher forum.
Whoever is the
Shall have made it 7/5 up to
No,
he will go
may-
after 7/5.
And Lordship, can you make the matter returnable on 23rd, last day of court, Lordship? So that
22nd I made it returnable.
and the report be given to the decree holder. The sheriff's report.
Instead of maybe preferred, maybe not shall be preferred. Because otherwise,
Sheriff.
But shall be preferred, how can it be?
Sheriff
Shall be preferred what?
If you are aggrieved that he is proceeding after,
not agree.
Shall be preferred.
Not shall be preferred.
Appeal you will.
My lord has said sheriff may.
no, sheriff may go after 7
My lord
to enable the parties to take
Yes,
necessary.
yes.
Saying she should not go. Actually, make it that.
My lord
If the sheriff goes, you mention the matter. Okay.
Very good.
Great.
Great.
Well, report copy may be will be given. Sheriff's report will be
The
given to the decree holder.
report of the sheriff shall be circulated to the parties.
And also
Appearing
copy
part.
of the application be served. I do not have a copy of this application. I'm an interested party.
They are third parties. You
Whatever steps you want to take, you take before the appeal court.
Copy of the application.
you are third party. You succeed there.
Because my application is pending J50.
So that will be hard out. In the meantime, you see.
Copy be served. All that I'm saying is a copy of this application in which Lordship is passing orders.
Yes.
That copy has to be served.
He's a 21 rule 97. First, let him succeed. How can you? They have no right to the proceeding.
Okay, if you are aggrieved against today's order also, you can prepare
I
that
am
application.
simply by non-service of copy of
Okay,
application.
okay. So against this order also, you can go higher up.
Service of, I'm only saying service of copy application which Lordship is hearing. I'm not asking anything.
So is it if it is a matter of right, he will serve it.
My Lordship is passing an order against my interest. So I am obviously an interested party. I am.
I am asking for order against judgment debtors. If and the law provides rule 35. Anybody bound by it.
He's not seeking any order against anyone else. Only judgment debtors. Because I'm not a
Rule
judgment
35. Order rule 35.
debtor. Record it. Otherwise, Lordship.
Okay, copy of this application may be served upon the opposite parties.
Grateful.
Are you a party here?
Well, opposite parties to the judgment debtors will be served.
This application is concerned.
EC will be served on judgment debtors. How can it serve on unknown people? Then what?
You see, your purpose will be served if you can get a necessary orders from the appeal court. Nothing will happen here.
I am all that
I'm grateful to
the service of a copy of application. which
Come on the
is-
next day. If you are agreed, come on the next day.
Get a copy and your
So this,
kindly record my submission that not I have asked for a copy of application and they refuse to give me a copy of application.
You
I
first,
have to have some
ask in writing. Write a letter. first.
anyway, whatever you want, you.
They kindly record this submission that I have asked for a copy of this application. which they are moving.
No, it's not necessary.
But my submission be recorded. Lordship may not. Lordship will reject the submission. Lord.
Okay, as what is your name?
Application J50.
Applicant J15 is not necessary, not a party in GA1 of 2023. At this stage, copy is not required to be served.
Great.
Your Lordship, I am for the petitioner, my lord. This is, there was a suit for eviction, your Lordship. Decree was granted in the year 2018, my lord. Thereafter, there was an appeal and the appeal has upheld the decree. Thereafter, my lord, we had filed the execution. There were few applications that were filed by a third party under Order 21, Rule 99 and 100, your Lordship. And there was also a direction in the decree for special officers to prepare for the mean profits, my lord. The report was prepared. We had filed an interlocutory application by virtue of which, my lord, that mean profits were to be, the amount that was decided, my lord, in the report was to be treated as a part of the decree. Now, my lord, I have filed another interlocutory application being GA number 5 for execution of that mean profit, my lord. And what I am pressing today is prayer I of master summons, that is disclosure of affidavit of assets.
If your lordship passes any order, my lord, I would humbly beseech your lordship to grant me an opportunity to file an opposition to this.
This is appearing for the first time.
Yes, appearing for the first time.
So let him file an affidavit in opposition.
Your lordship, if an
deal
affidavit of
with him,
assets also could be filed along with it without prejudice, my lord, that would only
There would be
expedite
a
the matter.
prejudice because, my lord, an order 21, rule 99 application is pending. And, my lord, there are
My lord,
peculiar
that is filed
circumstances
by
in
a
this
third
matter.
party, my lord, that the judgment
The
debtor
third
ought
party,
not to be
my
aware of.
lord, the
You are representing the
judgment debtor
He's
in the
looking-
suit.
So
my
you
lord,
confine
And his,
yourself with
yes, your
own
lordship.
rights.
yes,
your
now,
lordship.
Whatever the third party is doing, let him.
Yes, your lordship. And those
Incidentally,
applications
my
are
lord, the
pending,
third
my lord,
party,
and they
my
are
lord,
not appearing today.
this
my
is
lord.
one of those peculiar circumstances, my lord, where the third party is my mother. And the tenancy is in the name of my mother.
Your
The
lordship,
decree has been passed against me as an trespasser, my lord.
your lordship, applications were heard and
So that is why,
and
my lord,
at
I have to
that
bring
time,
all
the
those
Honorable
facts.
Coordinate Bench had passed
But I
an
have
order.
to file an affidavit.
directing-
Thereafter, your lordship decides, my lord.
GA applications are not put in this record. Okay.
Grants me an opportunity to file an affidavit. 2 weeks takes it after the
My lord,
vacation.
my new application is GA number 5.
Okay. Let learned advocates for the petitioner, decree holder, and learned advocate for the judgment debtor are present. Let all this GA1, GA2.
Your lordship, these other applications are filed by the third party, my lord, under Order 21, Rule 99, and they are not appearing today, my lord.
Okay. Let GA5 2025.
My lord,
up.
my lord, may all the applications be put up? If they appear on the next date, well and good. Otherwise, my lord kindly dismisses those applications because there is no one who is appearing, my lord, if that could be recorded.
GA2
No,
of
today,
2023, GA3 of 2024, and GA4 of 2024, and GA5 of 2024 be put up on the next date.
Your lordship will grant me an opportunity in the meantime to use an affidavit, my lord.
Actually, I have not gone through the application. Let me see the application first.
Your lordship is keeping it after the vacation.
No, not after the vacation.
GA5 की कौन था? GA5 of 25 application so
We-
be put up on
Vacation or time?
Next week, your lordship.
this is 6.
Yes,
It
your
would be
lordship.
too early, my lord. Next week thereafter. My lord. Six, I
Six,
have some
my-
personal difficulty, my lord. That's why.
My lord, then on 7th or 5th, your lordship.
8/5/2025.
Grateful, your lordship.
My lord, it may be after that week, my lord. That week I have some problem. Any day after that week, my lord. 10th, 11th, 12th, whatever is convenient, my lord.
My lord understands this is an execution matter, my lord,
Yes,
and it
I'm
is
not
pending
delaying
for a
it.
long time.
13. 13.
I'm grateful to you, lordship.
Grateful, your lordship.
Is the law. I'm very for
There are petitioners.
decree holder. This decree was passed. The price of goods sold and they have been long, in fact, question very, very astutely, not for a long time. But the decree was upheld on 10th April 2017. They have made payments thereafter. But now the remaining outstanding is there. Justice Kapoor directed that let there be a meeting of the parties. A meeting was held. Mr. Janto Mitra, the learned senior advocate, he appeared for them for statesman. Nothing definite was achieved. Thereafter, a further meeting was held at my office below, where the chairman of the statesman came, discussed, and he said that I will work out with the European counterpart in Europe, in Frankfurt, and work out something. Nothing is happening. Time is passing on, my lord. I don't know what my learned friend is going to say.
Go for the judgment date.
Your Lordship, in the meeting held in the office of my learned senior, his client did not appear. We were intimated that his client shall be appearing and we will have a virtual conference with the client. The contents, the minutes may be produced because my learned senior always makes a minutes of whatever meeting is done. In that meeting, we were present. We were there for 1 hour or so. His client, it was submitted by him that his client did not participate in it. So we should approach the client directly. We should approach. I did not interrupt when my learned senior was making submissions. When the court has asked me, I'm making the submissions. Thereafter, we tried to approach the in Germany. His client is based in Germany. We tried to approach them through the embassy as well. We are still trying to approach them and have talks. If my learned senior can make them sit on the table, and if we could have a virtual meeting, there could be an amicable settlement. GA1 has been filed by us, which is still pending, Your Lordship, for satisfaction of the decree. That we have, as per us, we have entirely paid the amount. The dispute over here is, Your Lordship, when the decree was passed, they are asking the money in euros. When it is converted into Indian money, the difference, that is the only dispute. As per us,
So
it should be
GA1 has
45
been
rupees.
It is pending.
both are pending. my lord.
GA, that is GA1.
One is filed by us, stating that the decree has been satisfied, Your Lordship.
I put it very, very brief, very brief. Yes. The managing director of Europe is based in Frankfurt. The meeting was held in my chamber. The chairman of Statesman came, managing director of Chairman came. We discussed. He said, I'll approach Europe directly. Give me the contact details. I gave it the name of the managing director. Thereafter, several months have passed. What they have done, what they have achieved is not mine. When was the meeting held last? About 6 months back. 6
More
months.
than
Back.
6 months.
Look, so there is no development in the meantime.
He's not, he just gave the name. There are no contact details given. If he can ask his client to sit on a virtual, we are still ready. Even today, if they ask, we are still ready to sit on virtual meeting. He's not physically present. His client is not physically present that we can sit. We are still not opposed to a amicable settlement. If his client is ready to sit virtually today, this week, next week, we are ready, Your Lordship.
How many meetings were held? Only one.
One was held in Saturday Club in the business center. Second was held in one. The question is not practicable for a German managing director to come down to Calcutta to hold the meeting. I said, whatever you are going to say, we'll respect, we'll go into it and do it. Then my learned friend's managing director said that I will approach your client. He took the name of Mr. Joachim Sattel, who is the managing director of Europe. It's a multinational company. And nothing achieved. What my learned friend says, I'm not disputing, I'm not going to go to that controversy. Question today is, more than 8 years have passed after the Supreme Court upheld the decree. I haven't got any light at the end of the tunnel.
Only part of the sum is liquidated.
Entire money has been paid, Your Lordship. If Your Lordship sees our GA1, entire money has been paid.
GA2 is an application made by them to vacate the order, which was passed in GA1. Will not be that as it may, whatever it may be. The short point boils down to is that whether I'm entitled to X amount of money or Y amount.
If it is not settled, okay, between the parties,
I leave it to Your Lordship.
then court has to pass an order.
Your Lordship.
Fixes a date.
I'm keeping it after vacation. If it in
Your
the
Lordship.
meantime,
After the vacation, Your Lordship pleases.
Market part.
It has not been heard that it can be marked as part heard. No, it has not. Nothing has been discussed. We will place our GA1. Then, after the matter is heard, it can be marked as part heard.
Why after vacation? Even earlier than that, Your Lordship can fix a firm date and time.
no, I'm just keeping it after the reopening.
Your Lordship, 1 week after the Mr. Jointo Mitro is appearing in this matter for me, on behalf of the respondent.
Market partner. Otherwise, I do not know what.
Your Lordship, I do not oppose, but this matter has not been heard.
This is for the first time.
Your
Your
Lordship.
matters are hard at length. They are
Your
not part
Lordship.
hard.
I do not oppose. This bench will only hear at the
Let
matter.
me do one thing. If I can send the matter to mediation,
Mediation has been done with.
Your Lordship, mediations,
Third
proper
party
mediation club, mediation center, it may be sent.
yes, mediation.
Yes, Your Lordship. I bow down to Your Lordship.
The meeting was held.
It is
His client did not participate in that.
Mr. Janto Mitra.
not in the
None
not
of-
in the presence of a mediator.
No.
Only to bipartite meeting. Okay. Learned advocate for the decree holder petitioner and learned advocate for the judgment debtor opposite parties are present. It is submitted by the learned advocates that although talks of settlement were held, but the matter is not yet settled. Stop. However, in the interest of justice, the parties are granted one more opportunity to settle the matter by holding necessary discussions. The matter stands adjourned till 17/6/2025 for necessary orders.
May I display also fix a time so that
The chamber matters, it will be taken up along with
understand.
yes.
But I can then 4.5 hours difference. If I have to take any instruction at that particular if the time is there, then I can tell them to be available.
Your Lordship, at 17, the matter may appear. Mr. Jointo Mitro shall be also appearing on that date.
At the top of the
Your
list.
Lordship.
Very good. Very, very good. It was giving a very bad impression in jail.
We have already paid. They are acting like Shylock. It was also from the bench that expression had come that they are acting like Shylock. They'll take every pound of flesh.
So you disprove them.
Your Lordship,
That they are-
that is the reason we filed GA1.
Supreme Court upheld the decree in one.
Your Lordship, we have paid entirely. Nothing is remaining.
Go beyond the degree.
Your Lordship, 45 rupees is the Indian currency converted amount. We've paid.
Supreme Court upheld.
So executing court is bound by the degree. It
Your
cannot go
Lordship.
beyond that. Okay.
Sincerely obliged, Your Lordship.
Last occasion, my lord, an accommodation was sought for by the petitioner, and my lord was pleased to make it clear that my lord, no further.
There is a question. Here is a unstamped document. Unstamped
That's
award.
one. That's one.
Yes.
My lord, that's my lord, the first hurdle that my lord, my learned friend must cross.
You have filed your affidavits.
My lord, that was not my lord called upon, but my lord, I do not think my lord, that would be necessary unless my lord, my learned friend crosses the first
Wait,
hurdle.
no. Even in affidavit stage, you take that point. You see, it is the duty of the court. If it is an unstamped document,
Correct.
it is the duty of the court to impound that document.
Correct, not in execution.
Whatever it is, at any stage, it is the duty of the court.
Correct.
Anyway, you file your affidavits.
Very well.
Learned advocate for the petitioner,
Why not written?
award holder, and learned advocate for the opposite party. Our data are present. As this matter is necessary to be decided by affidavits, that affidavit in opposition be filed by.
My lord, may we have my lord 2 weeks after vacation? My lord, affidavits were exchanged in GA1.
What is this GA for?
My lord, GA1, my lord, I find my lord affidavits are there.
This is GA1.
GA1. Affidavits, my lord, are there.
Okay.
So it's already there. So then my lord will kindly, my lord, keep it, my lord, for hearing.
Affidavit in reply is also filed.
Yes, my lord, I find that is there. Yes.
Yes. Opposition, which paragraph you have stated that?
That my lord, I need to check in my brief, my lord, the opposition is somehow missing.
Okay, then let it be not today. Come on the.
My lord, kindly fix a date, my lord, for hearing. My lord will come, my
I'm
lord.
making it not today.
My lord, one-liner order. Then, my lord, I think my learned friend is asking for an accommodation event.
Your Lordship, we are not asking for
Oh, then, my lord,
accommodation.
we can do this matter now.
Lordship,
No, question is, where is your affidavit you can't find?
My lord, later do, my lord, I will gather, my lord, the affidavit in the bank.
Yes.
Your Lordship, the instant execution application has been filed after by the award passed by the MSME in case 306 of 2014. Your Lordship, thereafter an injunction has prayer for injunction has been allowed by this court. And Lordship, by the order dated January 3 and 2022.
Yes, 3rd January.
Yes, Lordship.
Yes. Yes.
Your Lordship, as my learned senior is alleging that it is not with the certified copy, as it is not a certified copy, but Lordship, if you can see,
Stamped.
if
What
it
is
is
being
not
stamped?
stamped, Lordship, but a supplementary affidavit has been filed, Lordship, for the convenience of your Lordship. Your Lordship, at page 27.
Yeah, affidavit. Okay.
Your Lordship, we have we have again extracted the certified copy for the award, and Lordship, no stamps is needed for such award, and Lordship, it is a true certified copy, as Lordship can see at the pages, page 20, page 28, page 29, Lordship, all the pages of these orders has been is a certified copy of the award, which we have obtained from the MSME.
Yes, which paragraph in your opposition you have stated that?
Well, it's not my opposition. Milord, we have taken out an application, Milord, which is GA1. Milord, if Milord kindly just have a look at the master summons, Milord, this is an application for recalling, Milord, of the orders passed on 3rd of January and 18th of January. You have, Milord, receivers were appointed.
This is okay, GO1.
Yes, Milord. That is, Milord, my application, the award debtors application. There, Milord, not in so many words, Milord, you have said that, Milord, this requires stamping, but, Milord, this being a law point, Milord, I can always, Milord, place reliance on the statutory provisions. Milord, the award is before your Lordship. My learned friend has been, Milord, fair enough to submit that, Milord, the award was not stamped, but she adds one more line saying that the award, Milord, did not require any stamp. Kindly, Milord, just have a look at, Milord, the Indian Stamp Act once and, Milord, the schedule which applies to West Bengal.
And MSME with regard to
Milord, there
MSME
is no line of distinction drawn, Milord, by the Indian Stamp Act. No line of distinction drawn. Milord, when my learned friend says that, Milord, an MSME award is exempted from stamping, Milord, she must first satisfy that, Milord, where, Milord, the exemption lies. Let her, Milord, satisfy that, Milord, an exemption lies, Milord, anywhere in the statute. Indian Stamp Act does not, Milord, draw a distinction between an award, Milord, through, Milord, an individual arbitrator and an award, Milord, through MSME council. This is something, Milord,
in
which
the
is...
recalling application. What are your grounds?
Milord, there are so many, Milord, I just indicate, but, Milord, before...
This
Milord,
award was not challenged.
No, Lordship, this award was not challenged in the
I
GA.
answer, Milord, there is no
Yes.
award today. Milord, unless the award is stamped, Milord, there is no award today. Milord, there are, Milord, decisions to that effect from the Honorable Supreme Court even. Milord, kindly just have a look at, Milord, one. Milord, I'm not traveling with the Lordship, Milord, multiple decisions, but there are. Kindly take, Milord, 2003 volume 8 Supreme Court cases 565. Kindly, Milord, just have a look at, Milord, paragraph 4.
Yes.
2003 volume 8 Supreme Court cases, page 565. Milord, paragraphs 4 to 6. Milord, it says, paragraph 4 says, Milord, when, Milord, the award is, Milord, placed for enforcement, means, Milord, execution under 36. It is at this stage, parties can raise objections regarding the admissibility on account of non-registration and non-stamping under section 17 of the Registration Act. So, Milord, that's what, Milord, I am raising. So, Milord, today there is no award which can be, Milord, placed for execution. And kindly, Milord, have a look at the, Milord, provisions of Indian Stamp Act. So, my lord, this execution application, my lord, is really premature. And, my lord, unless I get an award stamped, my lord, my right to, my lord, challenge under section 34 does not arise. If there is no award, my lord, there cannot be any challenge under 34.
Your Lordship,
May I, my lord, conclude? And, my lord, kindly have a look at, my lord, Article 12 of, my lord, the schedule to the Indian Stamp Act. My lord, may I hand up? I'm sorry, my lord. It's clear, my lord, it covers all the award. My lord, on my lord's, my lord, left hand side towards the bottom, somewhere towards the bottom, my lord will get award. And then kindly take, my lord, MSME Act also. I'll just indicate, my lord, all the provisions of Arbitration Act, my lord, apply, my lord, to any arbitration under MSME Act. Kindly take, my lord, section 18, subsection 4. Oh, I'm so sorry. My lord, this is an award under MSME Act. So, my lord, section 18 of this act says, my lord, Arbitration Act to apply. No, there is no gainsaying that, my lord, MSME award does not require stamping. Any arbitration by MSME Council is guided by, my lord, 1996 Arbitration and Conciliation Act. And that's, my lord, the mandate of statute. Today, my learned friend, my lord, cannot say that, my lord, this is, my lord, an exempted category award. Then she must show under which provision of law, my lord, she is, my lord, claiming this from the bar. Where, my lord, Supreme Court is saying that at the time of enforcement, this is to be looked into. Grateful. My learned friend was suggesting I have not challenged. That is under section 34. Honorable Supreme Court has said, my lord, it's not a matter to be decided in 34. This is something to be decided here in the execution proceeding because of 47 CPC.
Okay, I'm keeping it for further hearing. Come ready on the next day.
Your Lordship, my learned senior wants to challenge the award on the stamping, an affidavit may be filed by them, so we can file our opposition on behalf of
I
that.
have taken out my
No,
application.
you have stated that with regard to stamp.
With regard to stamping, Your Lordship, if
Law
an
has
application.
so many words. This is a law point.
Okay,
my lord.
just
This is a law point.
Mr. Banerjee, learned advocate for the judgment dated petitioner is present. Year 1 of 2022 is taken up for consideration. Our learned advocate as supplementary affidavit is required to be filed in this regard. The petitioner, judgment dated, is granted opportunity to file supplementary affidavit by 8.
Milord,
No.
1 week after vacation. Milord, 1 week after vacation.
Supplementary affidavit on the reopening date after vacation.
1 week after, Milord, the reopening date, if my lord kindly cards us that time.
File affidavit, supplementary affidavit by 10/6/2025. Any opposition to the said supplementary affidavit may be filed by 16/6/2025. Let this matter appear on 17/6/2025.
So grateful. Grateful. Grateful, man. Grateful.
Okay, pass over.
My lord, I am for the decree holder, my lord. On the last occasion, lordship directed me to serve the copy of the amended tabular statement upon the substituted legal heirs, my lord. I have sent, my lord, but it was not served. It was returned. There are two addresses, my lord. One returned with remark left and another cannot be located. May I file the affidavit of service?
Legal heirs have left.
There are two, my wife and daughter. Both, we have received two addresses as per the original plan, my lord. One is at 43 Motisil Street and another is 264 Vivekananda Road. At both the addresses, I have sent the copy of the amended tabular statement and
It is returned.
it was returned to
Oh,
me left and another is cannot be located.
So you can take
Further steps.
make
my-
necessary application for
my lord.
substituted service.
Yes, my lord. Yes, I will do, my. It may be go out of list with may I come with an application, my lord?
Okay, learned advocate for the petitioner degree holder is present as service could not be affected upon the substituted years of the judgment dated. Learned advocate for the petitioner degree holder is granted opportunity to take necessary steps. Let this matter go out of the list with liberty to mention.
Grateful.
If I'm for the petition, pursuant the last occasion, my lord and pass an order, granted leave us to file the objection.
I'm on behalf of
Objection B. Key there. Through some objection. Original. This is the objection, lordship.
Copy of this.
Copy. Copy the
Yes.
Can I
Yes. This is the affidavit of assets. You have filed your objections.
I filed the objection which I have given lordship. I just want my lord to come to the after assets once. The lordship on the cost title. The lordship, it is I Surendra Kumar Bengani, son of late so and so, agent over so and so, office at 10 Clive, Calcutta 791. Lordship, if you see the notary affirmation, it is done from Delhi. On the bottom left side, the notarized is from Delhi. Area Delhi, Lordship, name Dharam Raj, area Delhi. And he is affirming in Kolkata personally.
Without mentioning the name at the Jurat portion on page 4.
At page 4, Lordship, you will see Surinder Singh Bengani on 7th November, so and so. He's himself signing.
It does not mention the place.
It does not mention place where is he in Delhi, from where he stays here, Calcutta, Delhi, wherever. This is one objection, Lordship. And second, my lord, if my lord comes to the order passed by the coordinate bench on 10th of September 2024, his lordship has it. 10th September 2024 order has 24. Vikas
Order
Patel. Justice Patanaik. Lordship, in the second page, Lordship will see. Here. See the second page. One bank account. We were aware of only one bank account at that point of time, and accordingly, prayer was made, and accordingly, the judgment letter was restrained from operating that bank account. Now, in his affidavit of assets, he has shown he is having 4 bank accounts.
Yes.
Lordship, my humble submission would be that all these 4 bank accounts should be restrained until my to that extent of my amount, which is.
What is your objection with regard to affidavit of assets?
Sir, Lordship, I'm coming to that. Thirdly, Lordship, Lordship comes to page 2.
Yes. 2 of your objection.
No, 2 of the affidavit of assets.
2 of the affidavit of assets.
At para number 6.
Yes.
He says my annual income is 4,30,000 rupees.
Yes.
And then on para 8, he shows 4 bank accounts.
Yes.
Lordship, turnover. What is more important here is turnover the page, Lordship, page 3. At para 9. The following debts are due to me. My lord, there are 7 or 8 items starting A, B, C, D, E, F, and next to G, H, I. My lord, if we add these dues, it turns up more than 35 crores. He says that he has to receive 35 crores from various persons. And his income is only 4,30,000 rupees per year. Number 1. Number 2, Lordship, this A. Prabhas Surana. Lordship will see at page 3, Prabhas Surana.
Yes.
Of sexual ceremony, 11 crore 44 lakh 9,433 due. Now she died about 8 or 9 months back. He's continuing with the name. How could he can get money from a dead person? I fail to understand. He has to. With 4 lakh income. And with 4 lakh income, Lordship, 35 crore loan. Unimaginable.
Let him put it on affidavit.
Let put this in affidavit.
We are Miller, at a stage where the decree will not be looked into. These are all beyond the decree. It's an affidavit of asset.
What I'm objecting,
It's an objection on the remaining bank accounts. I'm not standing in the way. Lordship will kindly direct the judgment data to be physically present for examination.
Lordship, what are the assets he has in Delhi? He now is in Delhi. He's not told the
We
court.
don't have any assets in Delhi. That's why we haven't mentioned it. And of course, it's the
Address of Delhi is not mentioned.
he's going to be
Lordship, the
subjected
assets
to
in Delhi is
cross-examination.
not mentioned. He says it's 35 crore dues. I mean, this is
Somebody with an annual
There are
income of
suit
4 lakh
pending on the
in
court
suit
with respect to item number 9.
Lordship will recall the last occasion I said some two suits have been decreed. He has got the money. That money is pocketed.
Did you give the particulars of those suits?
Not given the particulars. Lordship, I'll file a supplementary. I'll give you in 2 or 3 days time.
So record an order.
I will. Certainly.
Learned advocate for the petitioner, decree holder, and learned advocate for the judgment data opposite party at present are learned advocates. The affidavit of assets filed by the judgment data and the objections to the said affidavits be kept with the record. As a supplementary affidavit is required to be filed by the decree holder with regard to the sum realized by the judgment debtor from the decree, such leave is granted. Let supplementary affidavit be filed by 15. 2 weeks I'm granting you.
1 week, all on record.
But kindly allow me to file a rejoinder to the supplementary, because if there is any discrepancy with respect to the
Okay,
suit numbers, I will definitely bring that up.
8/5/2025. Rejoinder, if any, by 15/5/2025.
No, that will take some time. It has to be routed through Delhi, Your Lordship. is
No, no,
saying.
1 week. He's also taking 1
But
week.
I will have to draft it and send it to Delhi for it to be affirmed. That is the only difficulty.
Agreeing to the fact is in Delhi, Lordship.
Yes, he's
Just see his affidavit affirmation.
25/2025.
Surely.
Let this matter appear on 10/6/2025.
Lordship, two things. For 4 bank accounts, he's admitting it can be, this thing. So let it be.
As the affidavit of assets,
No, let us come back on the next day.
as the affidavit of assets
Lord,
furnished
I
by
must
the judgment debtor,
I must tell
He's
you,
admitted right now, Lordship.
let me
mentions
say,
4 other bank
Lord,
accounts.
Lord, I must tell this, Lord, there is already orders of injunction on these 4 bank accounts.
Let there be another
It is going to be
As far-
multiplicity.
Sir,
That
as
is
far
all
as I am
want to
concerned, I
say.
must have it also.
As the affidavit of assets mentions bank accounts of the judgment
That is why
debtor
these 4 have been mentioned.
at
The other 4
Axis
which does
Bank,
not have mention
Kharagpur
are
Road
not
branch,
mentioned.
being account number 9100100172745507, Bank of Baroda, NS Road branch, having account number 89890100007432, Karur Vaishya Bank, Shakespeare Sharoni branch, having account number 3102135000110008, and Yes Bank, KK Tagore Street branch, having account number 06465200002150, be also attached, and the judgment debtor is restrained from operating the said bank accounts till further orders.
Not without leaving apart the decretal amount.
Without leaving apart the decretal amount being rupees 53,87,114.35.
This one is. Okay. One more in that case. He must indicate his address in Delhi. Now he says he'll
My
send to
learned
Delhi.
friend is going to get an opportunity to cross-examine my witness.
No, that is a
I
different
don't
issue
think
for
so it is
him.
going to be.
He's
a
affirming
difficult
here, he's stating his office is here, and he's affirming in Delhi.
Anyway, you see, you are concerned with your dues. Let us forget about that for the time being.
He will not be chased.
Very
in
well,
that.
very well.
Ma'am, he will apply.
Second type of thing.
Then
All same except the degree amount will be different, Lordship. कितना degree amount?
Yes.
This is Lordship objection file. Next.
second wala.
Copy. Mr. No copy.
इधर 5387 ये दिया इधर
Yes, affidavit of assets file.
yes
Everything is same order, Lordship.
Same.
The amount will change. The decretal amount.
objection
The Lordship can retain
Judgment,
the order.
parties are same.
Party is same. Date of order is same. The Lordship can retain the order dictated now with respect to the earlier matter. It is only the amount as told by my
Decretal
learned friend that is going to change.
Party is not same, Lordship. The plaintiff is different.
Plaintiff is different.
The
judgment debtor, my lord, is the same.
Judgment debtor is same.
Affidavit, you are representing the plaintiff, that is degree holder.
Lordship, in both.
So this is
Second
affidavit of assets and objection is filed.
Yes.
Where? আচ্ছা, তাহলে ওটাকে সেম অর্ডার করে দেবেন। So here also decretal amount is
5387.
mentioned as
Like that.
5387.
So Lordship, there was an error in the first, in the earlier order, it ought to have been 6938.
তাহলে ওখানে এইখানে সবই এক থাকবে ডিক্রিটাল অ্যামাউন্টটা লিখুন yes what is the decretal amount
First,
Well,
in the first order
earlier
report,
matter, my
the
learned
earlier
colleague
matter,
is making
Lordship
submission.
has
that will also be corrected by this order.
that will be correct.
Yes, yes.
The first one I am saying 69 lakhs 38,000 060.70. And in the second order, my lord is just dictating 53 lakhs 87,000 114.35.
So far Dhruv Surana is concerned,
It is 69 lakhs.
69 lakh. Dhruv Surana means EC 40.
Yes.
So EC 40 te 69, huh? And the other
41.
is
41.
EC 41.
Lots.
53.87.
Okay, so for EC 41 is concerned,
It's
it is
53
lakh 87,114.
Lots.
Accounts number all will remain same.
Leave everything.
তাহলে ওই EC 40 তে ওইটা থাকছে 63 যেটা, আর 41 এ 53 lakh 87.
Development.
Extremely great.
My lord, I appear for the decree holder. This is within 2 years, so my lord, I am moving it, my lord. My lord, this arise out of an award case, my lord, pursuant to my lord, a land acquisition proceeding. My lord, initially, I'll just give your lordship the backdrop, my lord. Initially, there was an award passed by the my lord LA collector. That award was challenged by the landowners before the my lord, and the proceeding was my lord instituted before the special land acquisition judge at Alipur. The award was modified to a little extent. We were still aggrieved, and even the my lord state was aggrieved. State came to the High Court, the division bench, and we also filed a cross objection. Division bench further modified that award, and it is the division bench, my lord, judgment which is now, my lord, enforceable, my lord, as a decree of this honorable court. Now, my lord, kindly comes to my lord. If I take your lordship through the division bench judgment, I have annexed the my lord certified copy. Just after the tabular statement, it's there. Tabular statement. Well, just after the tabular statement, the division bench order is there. My lord has found. Yes. My lord, it is a judgment of my lord 2nd of December 2024. My lord, kindly permits me to place the first 2 paragraphs just for the facts.
Yes.
Instant appeal arises from judgment dated 17th August 2001, passed by learned additional special land acquisition judge at Alipur in LRA case number such and such at the behest of the state. At the very outset, we record that both parties agree to argue. I'm skipping that. My lord, then the next para. Facts more or less undisputed. Parties are at variance on the determination of market value of the acquired land and the rent compensation awarded by the reference court. So this was, my lord, the subject matter before the my lord division bench. Kindly sees the next paragraph, my lord. Subsequently, notification under section 4 was issued on such and such, followed by declaration as the said requisition land is further required for larger public interest, that is for purpose of providing accommodation to pavement hawkers. Land acquisition collector passed an award on 28 February 97 determining the market value of the land as on the date of notification at rupees 37,12,643 per acre, that is rupees 61,366 per kata. This was the my lord determination by the my lord land acquisition collector, with 30% solatium per annum and rent compensation of a 6% per annum rate. My lord kindly turns the page. Respondents did not agree the market value, which are my lord our clients, did not agree the market value determined by the land acquisition collector, prayed for a reference under section 8 read with section 18. Matter sent to reference court by the impugned order. Reference court determined the market value of the land as on the date of notification under section 4 at rupees 2,50,000 per kata. So my lord, that 61,000 and odd per kata increased to 2.5 lakhs per kata as per the land acquisition special land acquisition judge's order. And my lord, 30% solatium was continued, and 6% my lord rent compensation was enhanced to 9%. So this was the modification by the my lord land acquisition judge.
Yes.
Then, my lord, next para, appellant filed an instant appeal. Appellant was the state, assailing the order of the reference court in enhancing the market value of the acquired property and also the other component, namely rent compensation from 6% per annum. On the other hand, respondents, that is our clients, also filed cross-objection, assailing the findings of the reference court on the market price of the land as well as rent compensation, and both appeal and cross-objections are taken up together for final disposal. My lord, I placed only these paragraphs just for your lordship, my lord, to have a background of the facts. Now, my lordship will kindly come to the operative part of the division bench judgment. My lord, kindly comes to internal page.
Internal page 29.
29.
আর ডিগ্রিটাও সঙ্গেই লাগানো।
ওটা দেখাচ্ছি। Internal page 29.
Yes.
My lord, the fourth last paragraph starting with appeal and cross objections are accordingly disposed of. Lordship has found it. Just after that, impugned judgment is modified. Impugned judgment is of the land acquisition judge. It is modified to the extent that market price of the acquired land is fixed at 4 lakhs per kata. So, my lord, that 2.5 lakhs per kata determined by the special land acquisition judge was again enhanced to, my lord, by the appeal court. So, my cross objection got allowed and the state's appeal got dismissed. Other portion of the order remain uninterfered with. Now, the decree of the appellate court, lordship will find in the next page. This is what I am seeking, my lord, execution of today.
হিসেবটা দেখিয়ে দাও, হিসেবটা।
My lord, internal page 2, lordship will find modification is recorded in the decree and further order and decree that impugned judgment is modified to the extent that market price of acquired land is fixed at 4 lakhs per kata. Now, lordship will kindly come to one page from my affidavit, page 30. This is, my lord, an interim order, my lord, in that affidavit itself, my lord, just after the certified copies, where the, yes, my lord, after the, where the affidavit starts. Yes, my lord. Page 30, my lord. I'm grateful.
Yes.
My lord, this is an interim order that was passed when the appeal was, my lord, presented by the state. Because it was a money decree, my lord, or a money award, my lord, challenged as a decree, my lord, so under, my lord, provisions of order 41, my lord, the security, question of security had come. So, my lord, this application was filed. Kindly seize, my lord, from that, Recan 10083 of 2016, just after 4 lines from that, my lord, where the order starts. Appellant is directed to serve copy of this application upon respondents, intimating that the application will be listed for hearing such and such. Kindly skips the next paragraph, the third para. All further proceedings of execution case arising out of LRA case number 177 of 1999, pending before the learned second additional court of special land acquisition judge at Alipur, will remain stayed unconditionally for a period of 2 weeks. And if in the meantime appellant deposits the enhanced compensation amount together with interest up to the end of April 2017 in terms of the impugned order with the learned Registrar General of this court, interim stay which is granted above will continue till disposal of the application. It is made clear that in case such deposit is made, the learned Registrar General is directed to invest such deposit in short-term fixed deposit with any nationalized bank and keep the said deposit renewed from time to time till the disposal of the application, with a rider that further direction regarding payment of further interest will be passed at the time of disposal of the instant application. So this was, my lord, the interim application. Now kindly comes to page 32.
A certificate from the Registrar General.
My lord, this is a certificate from the Registrar General, Office of the Registrar General. My lord, date is, my lord, lordship will find March 2019. A sum of rupees 4 crore 11 lakh 59,371 has been deposited with this registry vide OD Chalan dated 8 September 2019 in CWFA 195 of 04. So they comply with this order, deposit, my lord, as on that date they compute and they deposit this money. Now, my lord, it is an admitted position that I have, my lord, realized a portion of this money, my lord, 50% kindly comes to a statement of account which has been
Order.
Oh, very well, my lord. Let me show, my lord, the order by which I was permitted to. My lord, kindly comes to page 33. All the above, this is an order passed by the division bench again, my lord, page 33.
Yes, 33.
All the above connected applications except Can 8 have been disposed of earlier. My lord, kindly turns the next page. My lord, the second paragraph. In this case, the land acquisition proceeding commenced in 1976. Award was made on 20th February 97. Disputed compensation amount is rupees 4,11,59,371. This is the exact amount which I showed your lordship just now from page 32, the amount which was deposited pursuant to that challan. The amount lies deposited with the learned Registrar General of this court. By this application can respondents pleading hardship pray for withdrawal of the amount pending the appeal and for expeditious hearing. Kindly turns the page, my lord. Following the Supreme Court judgment, we direct 50% of the said amount deposited with the learned Registrar General, together with accrued interest thereon, be released by the learned Registrar General to the respondents immediately. After encashing the term deposit and making payment in terms of this order, remaining amount shall be invested in a term deposit by the learned Registrar General in a fresh term deposit to the credit of the appeal. This amount should be released to the respondent duly authorized by the other respondents within 4 weeks of communication of this order. We note appellant has not taken any steps. My lord, directions were given, and thereafter, my lord, by the judgment which I showed just now,
We have been paid.
my lord, the appeal has been dismissed. Now, my lord, kindly comes to page 36. My lord, this is an entire computation of my claim amount today
As per the decree.
as per the, my lord, decree of the, my lord, appellate court. Kindly takes, my lord, the entry at page at serial number, the last, my lord, second last entry, less paid on 27th August 2021. Lordship will find a figure of 2,49 lakhs 03654. My lord, this is the figure, this is the amount which I got pursuant to the order passed by my lord Justice I.P. Mukherjee, my lord, allowing 50% my lord payment to be made by encashing that my lord fixed deposit. So I gave my lord credit of this amount also, and I have computed the entire calculation as per the my lord award, which has been modified lastly by the division bench judgment. This is the basis of my calculation. I communicate this to them, my lord. Kindly comes to page 37. This is my letter of January 2025 to the land acquisition collector.
Judgment letter.
Who is the, my lord, judgment debtor in this proceeding? I am the advocate on record for such and such. My lord, there are 3, my lord, heirs today. I am only, my lord, representing 2 of them. So I would be, my lord, whatever order I am seeking today is restricted to 2/3 of the, my lord, decretal sum, because 1/3 I am not entitled to. You are aware that by a judgment and order dated 2nd December, passed by Honorable Justice Harish Tandon and Honorable Justice Prosenjit Biswas, above FA number such and such, along with COT such and such, was finally heard and disposed of by passing an appellate decree by the Honorable High Court on the following terms. Impugned judgment is modified to the extent that the market price of the acquired land is fixed on rupees 4 lakhs per katha, other portions remain uninterfered with. In view of the aforesaid appellate decree passed by the court, on proper calculation, it appears that as on 31st December 2024, this is the cutoff date I take, a sum of rupees 20,76,02,880 is due and payable by you to my clients, including Srimati Aditi Mukherjee, the respondent number 3 in the appeal, in equal 1/3 share. A statement of account with regard to the particulars of 20 crore 76 lakhs is prepared on the basis of the appellate decree, which is enclosed for your perusal. You are called upon to forthwith make payment of, my lord, kindly notes, 2/3 of the said sum. This is what I am saying today, to my aforesaid clients immediately upon receipt of this notice, together with further interest at 15% per annum from 1st January 2025 until repayment. In default, so, my lord, this calculation of interest is again as per the, my lord, division bench judgments, which did not, my lord, modify or interfere with the, my lord, direction passed by the special land acquisition judge.
Anyway, so this order was not taken up before.
No, it has not been, my lord, challenged, and they are not making payment. Today, for the time being, my lord, kindly takes the tabular statement now. Twofold prayers I have, my lord. And there is, my lord.
This is paid on when? That is this. Oh, 2021.
21 it was paid pursuant to that order passed by Justice Mukherjee. The order was dated, my lord, the interim order which was passed was dated 5th of August 2021, and they paid us on 27th of August 2021.
এটা ওরা পেমেন্ট করেছে আমরা পেয়েছি 27th August 2021.
That is, my lord, date is also mentioned in that chart, my lord.
Thereafter, from 28 January 25 was your letter, demand letter?
Yes, my lord, we waited for some time. We waited for some time, and ultimately, my lord, in January, we demanded the money.
Second notice was also given to them.
There was another notice given, my lord, at page 40, my lord, 17th February, another notice.
No reply.
No reply to these notices, despite, my lord, their receipt.
Let this matter be heard out upon service of notice.
Yes, my lord, I am, my lord, today, my lord, it's, my lord, within 2 years, the decree. So I am not obliged to, my lord, give them notice.
It's the state authority. That is why it is better to serve and.
I will, my lord, kindly consider prayer A, my lord.
For the time being.
For the time being, prayer A. This will not, my lord, bother, my lord, even them, my lord. Because this, they are not today, my lord, shelling out this money from their own pocket. This is there with the registrar.
Yes, prayer A of the tabular statement.
Of the tabular statement. And prayer B is an order of injunction. It is only for security which I am seeking today. And I will give them notice and come back. For the time being, kindly passes order in terms of prayers A and B as interim, my lord. And I am entitled to this in law, my lord.
How much amount is lying there?
সেটা figureটা
My lord, the figure, my lord, there is a, my lord,
deposited interest
cash,
বলা যাবে।
there is a cash department, my lord, of our High
How
Court.
much is your claim?
My claim is, my lord, 2/3 of that 20 crore 76 lakhs. So, my lord, now the figure would be a little, my lord, it's half we had taken, 2.49 crores we had taken. It must have accrued some more interest.
Whatever it is, you see, it's better to have pass these orders because this is the state authority and the amount is lying with the Registrar General. It will not cause much prejudice.
Then, my lord, considers prayer B, at least this I am entitled to, my lord.
That is.
Injunction on the bank account, my lord, I am a decree holder. There is no challenge to the decree. In law, my lord, I am entitled to this at the first day, on the first day, my lord. Just because it state, my lord, the judgment data is state, that does not, my lord, would entitle them to, my lord, resist these orders from being passed. Man, before the court, they are on equal footing, like other judgment debtors.
Your amount due and payable is 13 crore.
94 lakhs 03711. So let this account be, my lord, there be an order of injunction. I am not asking for disbursal today. Prayer C is disbursal.
20 crore.
The total amount is 20 crore 76 lakhs and odd. My share is 13.94 crores. I am asking for an order of injunction on the, my lord, this.
Regarding register, how much amount is due? That
I will ascertain, my lord, because lordship can call for a report from the registrar as to how much lordship
can be done.
Yes, but today, my lord, kindly visualize as a decree holder, my lord, I am entitled to some protection. Prayer B, my lord, is only an order of injunction on bank account. State must have lots of fund there, my lord. Let them set apart only this fund, which I am entitled to. And I will give them notice and come back. They don't have better privileges than, my lord, any other judgment debtor once they have suffered a decree, my lord. That is, my lord.
But you see, there is no apprehension that the money will go out.
My lord, in an execution proceeding, my lord, that is possibly not the consideration. My lord, in an execution proceeding, it is, my lord, the court, my lord, would only see that the decree is implemented, enforced, executed. And to do that, my lord, the court will definitely give some kind of protection.
For a few days, nothing will happen. Okay.
My lord, I insist, my lord, prayer B, my lord, I will, lordship directs me to come back by 7 days, I'll come back. And then lordship wants to modify the order, lordship will. But kindly gives me, my lord, some protection, my lord. I cannot, my lord, I have lost my land in 1976. I have nothing, my lord, today. I need money, my lord. At least this, my lord, I can show the clients they have some injunction, they have some security that the money will come.
Okay. Learned advocate for the
Registrar should have to certify what is the
petitioner
amount.
decree holder is present.
Sign in his hand inclusive of
Our learned advocate for the petitioner decree holder. Reduce the petition file and the materials on record. It is submitted by the learned advocate for the petitioner decree holder that the order dated 2/12/2024 passed by the Honorable Division Bench in FA 195 of 2004 with COT 1045 of 2005 has reached its finale and the
decree has been drawn up, my lord, as per this judgment.
And the opposite party judgment debtor is not complying the said decree. Said decree in spite of the reminders. Learned advocate for the petitioner, degree holder, submits that necessary interim relief be granted and the matter may be proceeded upon causing service of notice upon the judgment data. In the facts and circumstances, no, which relief you are seeking?
My lord, for the time being, only B. A lordship may call for a report from the registrar indicating what is the, my lord, total amount which is now lying in that fixed deposit with the accrued interest. I've given the particulars.
Let there be an order in terms of prayer B of the tabular statement filed in this execution case. The judgment debtor, opposite party, is restrained from operating a bank account maintained at Reserve Bank of India, BBT Park, Kolkata, in the name Land Acquisition Collectors Account, requisition PL account number 29, without setting apart a sum of rupees 13 crore 94 lakh 3,711 and 711. Let notice be issued upon the judgment debtor. Let this matter.
My lord, a report may be called for from the Registrar General regarding the, my lord, amount the Registrar General is holding.
The Registrar General is also
Appellate side, Registrar General appellate.
No, Registrar General is general.
Yes.
The Registrar General is requested to
Appellate
submit a
side is
report
another Registrar General.
as to the amount which is lying deposited VIP OD Chalan number 1439 dated 8/9/2017 in connection with FA 195/2004. Within on the next date fixed. Let this matter appear on
15th, we can come back, my lord.
the 15/5/2025.
I'm very grateful, my lord.
Service tabula.
Lordship will also direct me to serve the, my lord, judgment debtor.
Yes, sir. That direction is.
That direction is.
Let necessary notice be served upon the.
Very. I will also, my lord, independently serve him a copy. Grateful, my lord.
Judgment data.
Upon the judgment debtors.
Only one judgment debtor.
Okay.
Grateful.
Item number 1.
Please, Your Lordship, my lord. Sorry, I was not there in the first call, my lord. This is my application in a suit of 1969. The suit was filed for eviction of a tenant. For the defendant, I am being led by Mr. Anirban Das. Although he has come to the court, but suddenly he is not feeling well. I'm praying for not today.
No, you are praying for in this matter. You are.
My lord, this is after affidavits are complete. This is for eviction.
Let it be not today.
He's not well.
Come ready on Tuesday. It will remain in the same position.
Very well. Grateful.
Grateful. Not today.
Mr. Miller? Madam, this is an application for the defendant number 3 for amendment of their written statement. नाम तो लिख दो।
Your application, you are for?
I'm for the plaintiff of opposing.
But in this matter, my lord, what happened that the suit for
Dependent
the
number
specific purpose of the contract, my lord, we are challenging this. My lord, by this amendment, my lord, we are seeking, my lord, that the cause of action of the stand of the plaintiff will not be disturbed. What happened that we have filed our written statement. In their opposition, my lord, they have taken the point that we have not, we have got the opportunity to add all these points in our written statement.
At what stage this
My
application
lord,
is taken out?
that is, second point is that when the issues are framed, my lord, so comments of proceedings start. It is not correct, my lord. I have covered with the judgment, my lord. Unless trial is begin, my lord, that the issues framed, that is not the point to stall that my prayer
It
of
was
the
fit for
amendment.
witness action.
My lord. Yes, witness, but a witness action also started. My lord, I have covered the judgment, my lord. But first of all, my lord, I come to that. If you not to kindly see my prayer. My lord, in paragraph, my lord,
16.
16. No, 16. My lord, paragraph 8 and 9. My lord, all the points which I want to add.
Yes.
In my written statement, those points are there. My lord, the law point is covered. My lord, that the agreement which is now they are harping on, that is not, that is amongst impounding, my lord. Because if it is taken as an agreement for sale, then that agreement for sale must be, should be stamped and also registered. My lord, I have covered with the my lord, decisions, my lord, in my lord.
Your paragraph 8.
My lord, paragraph 9, my lord. Paragraph 9, I have suggested all the points which are required to be.
What is the schedule of your amendment?
My lord, schedule of the amendment, my lord,
Page
paragraph.
number 11.
Page number 11.
11.
Correct?
Yeah, 11.
Yes, my
Paragraph
lord.
16.
Yes. Paragraph 16, my lord. Paragraph 16.
Page number 12.
Oh, page number 12.
Page number 12.
Yes, my lord. Paragraph 16, my lord. That after the paragraph 15 of the my written statement, these should be added, my lord. My lord, first,
In A, B, C, D,
yes.
E, F, G.
My lord, yes. That is there. My lord, if your lordship kindly come to first point, my lord, have taken that the document is invalid document. Because the document they are harping on, this is an assignment document. Assignment of the original agreement for sale. Because, my lord, the agreement for sale with the buyer, we are the owner of the property. I am defendant number 3, one of the one, having the 10.8 or 18% of the property. My lord, we sold the property to the in 2010.
No. Let us come to the points. What are you
lord,
seeking in your amendment?
My lord, seeking in the amendment, my lord.
So what was your previous written statement? 15, 16.
15.
Have you annexed this previous written statement?
Yes. Yes. My lord, that is in annex. My lord, at page 53, 54, my lord.
Yes.
Paragraph 15.
This is the amendment which you are seeking now.
We are seeking now, my lord.
So earlier it was only.
Yes. Earlier,
This
my
was
lord,
this
these points not taken, my lord.
Yes.
This point not taken.
Page number 48 থেকে শুরু হচ্ছে.
Very well. In considering amendment petition, the court cannot go to the merits of the case.
My lord, yes.
That has to be established.
Yes. My lord,
the thing is whether you have taken out this amendment in compliance with Order 6, Rule 17. That is the thing.
That is the point. My lord, my lord, my first point is that point. Well, unless these points are covered, my lord, in my written statement, then at the time of hearing or I cannot put my questions to the cross-examination.
Yes, what are the judgments you are relying?
My lord, I am judgment. Before judgment, my lord, I am showing your lordship.
মেরিটে ঢুকবে না কাকু, আপনি জাজমেন্টটা
না
দেখিয়ে
না
দিন।
আমি judgment টা দেখাবো খালি একটা জিনিস দেখাবো yes my lord stamp duty my lord that is
And
section
these are the questions to be dealt up
my
at
lord
the
my
time
lord
of trial.
but
Impounding
these
section
my lord,
35 of the
yes
Stamp
yes
Act.
these points
Why
my
these
lord,
are being taken at this
regarding
stage, I don't
amendment, what
understand,
are you?
sir.
that these points my lord I have taken in the
You have
meditation
taken for in the amendment
yes
petition.
yes
Okay.
my lord that is
খালি
the, if
amendment
relating to sale of lease comes sale of immovable property my lord the same duty as a conveyance for market is an agreement so conveyance deed is and unless my lord section 35 my lord that instrument not duly stamped inadmissible in evidence my lord kindly sir.
কাকু জজ সাহেব খালি অ্যামেন্ডমেন্টে জাজমেন্ট গুলো দেখতে চাইছেন,
Yes.
নাথিং এলস।
These points my lord I have taken my lord in earlier written statement I have not taken but and another my lord in this judgment my lord they have taken 2 points that is that so far the written statement I have filed those points not taken and another is already issue suggested issues framed my lord so if your lordship kindly come to my lord, I'm handing over the judgment Usharani Devi তাই না my lord reported in my lord 2008 3 SCC page 717
Yes.
my lord amendment of the pleading exercise
প্যারাগ্রাফটা বলে
my lord paragraph কতটা আছে বলো
প্যারাগ্রাফ 13
paragraph 13 my lord paragraph 13 my lord
Yes.
my lord Mr. Bhankura on the other hand invited our attention to another decision of this court in para 17 of the decision it was held and observed before we part with this order we may also notice that proviso under order 6 rule 17 provides that amendment of pleading shall not be allowed when the trial of the suit has already commenced. For this reason, we have examined the records and find that, in fact, the trial has not yet commenced. But here also, trial has not been commenced. It appears from the record that the parties have yet to file their documentary evidence in the suit. From the record, it also appears that the suit was not on the verge of conclusion as found by the High Court and the trial court. That apart, commencement of the trial as used understood in the limited sense as meaning the final hearing of the suit, examination of witness, filing of document, and addressing of arguments. As noted herein before, parties are yet to file their document. We do not find any reason to reject the application for amendment of the written statement in view of the proviso under order 6 rule 17, which confers wide power and unfettered discretion on the court to allow an amendment of the written statement.
Yes.
My lord.
Next.
My lord.
2018 SCC
My lord, it is also reported in 2018 2 SCC 347.
paragraph 17
Very well. I shall go through this. You
My
give
lord,
the
paragraph
citation.
17, my lord.
17 onwards
17.
Anyway, give this judgments. I shall go through this.
My lord. My lord, but it's still one judgment that is paragraph.
Page number it is to be mentioned. It is by the petitioner.
Yes, yes.
পেজ নাম্বারটা বলবেন
Page হলো 347.
কত প্যারাগ্রাফ এটা
Paragraph কত? 17. My lord, paragraph 17. Kindly see the paragraph. It is for the reason that firstly, paragraph 7 at
Paragraph 17.
my lord, paragraph 17.
Yes.
My lord, it is for the reason that firstly, the suit is still at the initial stage. That is, the trial has not been begun. Second, the proposed amendment sought in the plaint does not change the nature of the suit. But here also, we have not interfered into the what they have stated in the cause of action or whatever. My lord, third, the application could not be said to have been filed by the plaintiff belatedly because the suit had been dismissed by the trial court is not maintained. My lord, last sentence. Fourth, the courts in this circumstance should have been liberal in allowing the proposed amendment, my lord.
So these are the two judgments you have relied upon.
My lord, other judgment is also, my lord, kindly come to 2020, latest judgment, my lord. 2025, one Indian civil cases, Calcutta High Court branch, Honorable Justice Divas Ranjan, my lord, will pass the order, my lord.
The Calcutta High Court.
My lord, Calcutta High Court.
Okay.
কোন প্যারাগ্রাফটা বলে দিন জজ সাহেব।
My lord, paragraph 21, 22, my lord, that is very high. 21 and 22. My lord, 21 and 22, my lord.
Yes.
My lord, 21, now coming to the issues regarding the amendment petition, changing the nature and character of the suit. My lord, this point they are not taken in their opposition, my lord. In my humble self, does not have any basis, as the main contention dispute regarding the instance is deeply interlinked with the issue that is proposed to be raised by the petitioner through amendment. My lord, now coming to the stage on which the amendment petition has been proposed to be filed by the petitioner, that argument raised by the counsel appearing on behalf of the defendant with regard to the proviso of the order 617, wherein it is stated that no application for amendment shall be allowed after commencement of the trial, unless the court is. My lord, these are all said after commencement of the trial. My lord, even in the argument stage, my lord, that amendment could be sought. My lord, that is also, there is also
It is exception. Normal course, it should not be
yes,
allowed.
my lord.
In exceptional cases,
But
it can be allowed.
but the trial has not been commenced, my lord.
Yes,
In this case, only the issues, my lord, framed, my lord. My lord, last one judgment, my lord. That is reported 2005-13 Supreme Court, Sajjan Kumar, my lord. Page 89, paragraph 5, my lord. Paragraph 5. Paragraph 5, my lord. 2 pages judgment, my lord.
Yes.
Having heard the learned counsel for the parties, we are satisfied that the appeal deserves to be allowed as the court, while rejecting the prayer for amendment, has failed to exercise jurisdiction vested in it by law, and by the failure so exercised, it has occasioned a possible failure of justice. Such an error committed by the trial court was liable to be corrected by the High Court in exercise of its supervisory jurisdiction, even if 115 CPC would not have been strictly applicable. My lord, it is true that the plaintiff appellant ought to have been diligent in promptly seeking the amendment in the plaint at an early stage, my lord. At an early stage, that is true. Of the suit. More so, when the error on the part of the plaintiff was pointed out by the defendant in the written statement itself. Still, we are of the opinion that the proposed amendment was necessary for the purpose of bringing to the fore of the real question in controversy between the parties, and the refusal to permit the amendment would create needless complications at the stage of the execution in the event of the plaintiff appellant succeeding in the suit, my lord. The merit of the suit, my lord, will not be disturbed, my lord, because if the amendment is allowed, my lord.
Anyway, Order 6, Rule 17 is to be complied.
My
And in exceptional circumstances, it can be allowed even at the trial stage also.
Even at the trial stage, even at the argument stage also.
Yes,
sir.
that is the trial.
Even if
on the
my
argument
lord,
stage also.
we have decision, my lord, your lordship will know that
General-
even in the execution stage also amendment could
General
be.
rule is not before trial, but
Not
in
before.
exception, yes.
Yes,
No question of going into the merits
My-
of the amendment.
my lord.
Yes, Mr. Mukherjee, you want to submit today or you want to?
I can just go through these judgments and I can come up.
You want to come up on the next day? Yes. Learned advocate for the parties are present. our learned counsel for the petitioner defendant.
Defendant number 3, my lord.
Petition defendant number 3. Mr. Mukherjee, learned advocate appearing for the plaintiff opposite party 6 times. The matter stands adjourned till Tuesday. Come on Tuesday.
Thursday করুন না।
Oh, let it be Thursday, 8/5/2025.
অসুবিধা নেই তো?
না।
Thursday মানে।
এটা ঠিক করে ঢুকিয়ে নাম্বার গুলো judgment গুলো।
My lord, the only thing that, my lord, it will be at the same position.
Yes, yes, yes. In the same position it will appear. Yes, Mr. Mitro, your matter will be taken up on the next day for orders.
For logical, keep it on top. Otherwise, order last item because
দাম দিয়ে দিয়েছো?
if next day, if it can be normally order is taken up before the new chamber.
আচ্ছা।
It can be a next.
For orders চেম্বার হিসেবেই হবে কিন্তু আগেবারই এটা দেওয়া হবে।
On the next day, I am seeking the liberty on the next day. If something left, my lord, only 2 minutes, my lord. If something left, then I
Reply.
can, my lord, in reply and also. বাইরে দিদি ওই জাজমেন্ট গুলো দিলাম ওগুলো থাকছে তো ওনাকে ডাকতো ওনাকে ডাকছে অল্প চুলালা হ্যাঁ ওগুলো একটু পিটিশনার বলে লিখে দেবে সরি হ্যাঁ হ্যাঁ
লিখে দেবো এখন দেবেন
লিখে দেবো
কোনটা দিয়েছে মনে হচ্ছে
হ্যাঁ
ঠিক আছে
কোনটা বলছি বলুন তো
চারটে দিয়েছে
হ্যাঁ হ্যাঁ হ্যাঁ
লেখা আছে
2018 একটা দিয়েছি
2008
18 to SCC 347
হ্যাঁ 2008 টা
হ্যাঁ 2008 টা PSCC 717
আর একটা 25 ইন্ডিয়ান সিভিল কেসেস
হ্যাঁ
এই জোসেফ চলে আসবে
জোসেফ ঢুকে যাবে এই হ্যাঁ লিখেছি না লিখেছি সব
এটাই তো ঠিক
এইটা না এইটা এই একটা 2005-13 SCC 89
2025 ইন্ডিয়ান সিভিল কেসেস
হ্যাঁ 2021 ইন্ডিয়ান সিভিল কেসেস 1 ঠিক আছে 1 ক্যালকাটা
নাম্বার
না
অনলাইন পেয়েছে
সেভেন এইট ছিল গতকাল
পিএলএম পিএলএ তোমার 221 আর 1990 যে 2-3 রিপোর্টটা হলো না ব্যাংক চেম্বারে গিয়ে ব্যাংক অফ করে চলে আসে চাপা
না আবার দুটোর সময় বর্তমান থেকে নতুন হয়েছে টুডে ইজ দ্য ফার্স্ট ডে সময় নতুন নতুন না সিভিল সেকেন্ড অ্যাপিল গুলো নিচ্ছে 654 না 655
কারণ বেশি দিন হয়নি তো সেটা বলছি তাহলে কি জমে যাবে না
মেনশন করবে ল্যান্ড